Welcome to our comprehensive video on the Employees Provident Fund Scheme, 1952. This video lecture will delve into the various provisions of the EPF scheme, providing you with a thorough understanding of this crucial component of India's social security framework. The Employees Provident Funds Scheme applies to all factories and establishments covered under Sections 1, 3, or 1, 4 of the Act. However, there is one key exception: the scheme does not apply to tea factories located in the state of Assam. The Employees Provident Funds Scheme covers any person employed for wages in connection with the work of an establishment, whether manual or otherwise. This includes individuals who receive their wages directly or indirectly from the employer. It also applies to those employed through a contractor, apprentices, except those engaged under the Apprentices Act of 1961 or under the standing orders of the establishment. Apprentices under the Industrial Employment Standing Orders Act 1946 can only be excluded if the standing order is approved by the Joint Commissioner of Labour. In the Employees Provident Funds Scheme, the definition of family and children is important for determining beneficiaries. Children includes legitimate children and adopted children, provided adoption is legally recognized under the member's personal law. For a male member, the family includes his wife, his children, whether married or unmarried, his dependent parents, the widow and children of a deceased son. For a female member, the family includes her husband, her children, whether married or unmarried, her dependent parents, her husband's dependent parents, the widow and children of a deceased son. A female member has the option to exclude her husband from her family under the Employees Provident Funds Scheme. If she submits a written notice to the Commissioner expressing her desire to exclude her husband, then both her husband and his dependent parents will no longer be considered part of her family for the purposes of the scheme. This exclusion remains in effect unless the member cancels the notice in writing at a later time. Under the Employees Provident Funds Scheme, the term pay includes basic wages, dearness allowance, retaining allowance, and the cash value of any food concession. Apprentices are defined as those certified under the standing orders applicable to the factory, or those declared apprentices by the authority specified by the appropriate government. Continuous service refers to uninterrupted service but also includes periods interrupted by sickness, accidents, authorized leave, legal strikes, or cessation of work not due to the employee's fault. An excluded employee under the Employees Provident Funds Scheme refers to an employee who has withdrawn the full amount of their accumulations from the fund, as per Clause A or C of subparagraph 1 of paragraph 69. An employee whose pay exceeds 15,000 rupee per month at the time they are otherwise entitled to become a member of the fund. An excluded employee is not required to become a member of the fund unless they choose to do so voluntarily. Under paragraph 26 of the Employees Provident Funds Scheme, all employees earning wages are entitled to membership. This includes casual or temporary employees, daily wage workers, contractual employees, and trainees who are not engaged as per standing orders. Every eligible employee must be enrolled for Provident Fund membership from day one. However, an excluded employee, as defined earlier, is not required to become a member of the Provident Fund. If an excluded employee wishes to be enrolled, they may do so with the permission of at least an Assistant Provident Fund Commissioner, as outlined in paragraph 26(6). As per paragraph 34 of the Employees Provident Funds Scheme, every employee must submit a declaration in Form 11 when joining an establishment. The effect of Form 11 is as follows. If the employee is not a member and their pay is up to 15,000 rupee per month, they must be enrolled. If the employee is already a member, they must be enrolled regardless of their pay. If the employee is a former member who has withdrawn their provident fund, they must be enrolled again if they are below 55 years of age. Employees aged above 55 or those who have retired can be excluded from enrollment. We will discuss various provisions related to membership. Para 26, classes of employees entitled and required to join the fund. Para 26, a retention of membership. Para 26b, resolution of doubt regarding membership. Para 27, exemption of an employee. Para 27a, exemption of class of employees, and Para 27r, terms and conditions of exemption, and Para 28, transfer of accumulations from existing provident funds. In certain cases, employees can receive exemptions under the Employees Provident Fund (EPF) Act of 1952. Firstly, exemptions are granted under Section 17(2) of the EPF Act. These are specific to certain employees. Secondly, individual employees may be exempted through the Regional Provident Fund Commissioner under paragraph 27 of the EPF scheme. Lastly, an exemption can also be extended to a class of employees by the appropriate government, as per paragraph 27 of the same scheme. The contribution towards the Employees Provident Fund, or EPF, is structured in a balanced way. Both the employee and the employer contribute 12% of the employee's wages. From the employer's share, 3.67% is credited to the Provident Fund account, while 8.33% goes into the Employees Pension Scheme, or EPAs. Additionally, employers are required to pay administrative charges. This includes 0.5% of wages as administration charges for the EPF scheme, and another 0.5% towards the Employees Deposit Linked Insurance, or EDLI scheme. Basic wages, for the purpose of the Employees Provident Fund, include all emoluments earned while on duty. However, certain components are excluded, such as bonuses, house rent allowance, HRA, overtime allowances, dearness allowance, which accounts for the rise in the cost of living, commissions, and other gifts provided by the employer. For contribution purposes, basic wages, dearness allowance, and the cash value of food concessions are considered. This is outlined in Section 2(b) and paragraph 29 of the EPF scheme. In the first instance, the employer is responsible for paying the contribution and other charges by the 15th of every month, including contributions for contractor employees, as outlined in paragraph 30. The employer's share of the contribution should not be deducted from the employee's wages, according to paragraph 31. Meanwhile, the recovery of the employee's share is governed by paragraph 32. For contract employees, the principal employer must recover contributions from the bills raised by the contractor, as per Section 8 of the EPF Act. When an employee exits, the employer must obtain the claim form, signed by the exiting member, as required by paragraph 72(5)(b). After ensuring all formalities and attestation, the form must be submitted to the Provident Fund Office, especially if the member must wait for 2 months to make a claim. If the member submits the claim directly to the PF office and it's referred back to the employer must return the duly attested form to the PF office within 5 days. The employer is obligated to follow these procedures under paragraph 72, and failure to comply is punishable under paragraph 76, read alongside Section 14(2). These steps help ensure that claims are settled within 20 days, as outlined in paragraph 72(7). Under the EPF scheme of 1952, members can avail themselves of various forms for different purposes. For advances, members need to use Form 31 or Form 14. For final settlement, the member must submit Form 19. In case of settlement for a nominee, Form 20 is required. Lastly, for transferring funds to a new account, Form 13 is used. Now we will discuss about advance withdrawal, which is non-refundable advance taken by members. The advance is for the purpose under Para 68B, 1. A purchase of site for construction of house. Eligibility. Member must have completed at least 5 years of service. The land must be in the name of the member, spouse, or jointly owned. Amount. Up to 24 times the monthly basic wages and dearness allowance or the total employee share with interest, whichever is lower. The advance should not exceed the total cost of the site. The advance is for the purpose under Para 68B, 1. B. Construction of house on owned site. Eligibility. Minimum of 5 years of service. The site must be owned by the member, spouse, or jointly. Amount. Up to 36 times the monthly basic wages and dearness allowance or the total employee share with interest, whichever is lower. The advance should not exceed the total cost of construction. The advance is for the purpose under Para 68B, 1. C. Purchase of house flat, outright or from housing society, or purchase of site with house. Eligibility. Minimum of 5 years of service. The property must be registered in the name of the member, spouse, or jointly. Amount. Up to 36 times the monthly basic wages and dearness allowance or the total employee share with interest, whichever is lower. The advance should not exceed the total cost of the house flat. The advance is for the purpose, for additions, modifications, or improvements to an existing house. Relevant provision, Para 68B, 7, of the EPF Scheme. Eligibility. Minimum of 5 years of service required after the first construction or purchase advance has been taken. The house must be in the name of the member, spouse, or jointly owned. Amount. Up to 12 times the monthly basic wages and dearness allowance or the total employee share with interest, whichever is lower. Can only be availed once during the service. The advance is for the purpose, repayment of an outstanding home loan. Relevant provision being Para 68BB of the EPF Scheme. Eligibility being minimum 10 years of service required. The property should be in the name of the member or spouse. Amount available is up to 36 times the monthly basic wages and dearness allowance or the total employee share with interest, whichever is lower. The advance is for the purpose, financial assistance during periods of lockout or factory closure. Relevant provision, Para 68-H of the EPF Scheme. Eligibility. Factory must be closed for more than 15 days, and the member must not have received wages for more than 2 months. Amount. Up to 100% of the employee share with interest. The advance is for the purpose, financial assistance during the closure of a factory where the worker has not been receiving wages. Relevant provision, Para 68H, 2, of the EPF Scheme. Eligibility. The factory must have been closed for more than 6 months, and the member should not have received wages for at least 6 months. Amount. The member can withdraw the full employee share with interest, 100%, in such cases. The advance can be availed only once while the factory remains closed. The advance is for the purpose, financial assistance to EPF members during periods of unemployment after being laid off, retrenchment, or due to the closure of a factory. Relevant provision, Para 68HH of the EPF Scheme. Eligibility. Member must be unemployed due to retrenchment or factory closure. Amount. Up to 100% of the member's own share, employee contribution, with interest can be withdrawn. No minimum service requirement. The advance is for the purpose, medical treatment for self, spouse, children, or dependent parents. Relevant provision, Para 68-J of the EPF Scheme. Eligibility. No minimum service period required. Available for treatments such as hospitalization lasting for more than 1 month or major surgeries, or for diseases like cancer, TB, leprosy, paralysis, or heart ailments. Amount. 6 times the member's basic wages and dearness allowance or the total employee share with interest, whichever is lower. In cases of serious illness, cancer, heart disease, etc., the full employee share with interest can be withdrawn. The advance is for the purpose to meet the expenses of the marriage of self, son, daughter, or siblings. Relevant provision, Para 68-K of the EPF Scheme. Eligibility. Member should have completed at least 7 years of service. The advance can be availed for the marriage of self, son or daughter, sibling, brother or sister. Amount. Up to 50% of the member's share, employee's contribution, with interest in the EPF account. This advance can be availed up to 3 times during the member's service. The advance is for the purpose, financial assistance during natural calamities like floods, earthquakes, etc. Relevant provision, Para 68-L of the EPF Scheme. Eligibility. Applicable in areas declared as affected by the central government or a state government. Amount. Up to 5,000 rupees or 50% of the employee share with interest, whichever is less. Can be availed once in a financial year. The advance is for the purpose, financial assistance to members who become permanently and totally incapacitated to work due to physical disability. Relevant provision, Para 68-M of the EPF Scheme. Eligibility. The member must be certified by a competent medical authority as being permanently and totally disabled and thus unable to work in the establishment. Amount. The member can withdraw the entire accumulated EPF balance, including both the employee's share and the employer's share with interest. No requirement for a specific service period. The advance is for the purpose, purchase of equipment by physically disabled members to reduce hardship or aid mobility. Relevant provision, Para 68-N of the EPF Scheme. Eligibility. No minimum service required. Amount. 6 times the basic wages and dearness allowance or the total employee share with interest, whichever is less. The advance is for the purpose, withdrawal within 1 year before retirement. Relevant provision, Para 68-NN of the EPF Scheme. Eligibility. Member should be 54 years of age or above. Amount. Up to 90% of the total EPF balance including employer's share with interest. Let us discuss final settlement of PF balance. In following cases, immediate settlement of PF balance to happen without waiting period of 2 months, retirement after attaining 55 years of age. Retirement on account of total and permanent incapacity due to bodily or mental infirmity. Migration from India for permanent settlement abroad or taking employment abroad. Termination of service on retrenchment. Termination on voluntary retirement. Whereas in other cases settlement of PF balance to happen after waiting period of 2 months, transfer of a non-retrenched employee from a closed establishment to uncovered establishment. Transfer of an employee from a covered establishment to an uncovered establishment under the same employer. Other cases like resignation, leaving service, etc. It is important to note that female members leaving service for the purpose of getting married, waiting period not applicable. Now we will discuss about final settlement of PF account on death of member in favor of nominee family member, S, legal heirs. It is the duty of the employer to ensure that each member submits a declaration in Form 2, R. This form nominates individuals who will receive the member's accumulated funds, including the assurance amount under the Employees Deposit Linked Insurance (EDLI), in the event of the member's death. A member has the discretion to distribute the amount in the fund among their nominees as they see fit. Additionally, members can now conveniently submit their nominations online through the e-nomination feature available on the member portal. The nomination for EPF must be in favor of one or more persons from the member's family. Any nomination made in favor of someone outside the family will be considered invalid. After marriage, the member is required to submit a new nomination, as any prior nomination will automatically become invalid. If a member has no family, the nomination can be made in favor of any person or even an institution. However, if the member later acquires a family, the previous nomination will immediately become invalid, and the member must submit a fresh nomination for one or more family members. According to paragraph 70(I), if a nomination exists, the payment is made to the nominee in accordance with the details provided in Form 2(R), the nomination and declaration form. Under paragraph 70(2), if no valid nomination exists, the payment is distributed equally among all members of the family, as defined in paragraph 2(G) of the Employees Provident Fund Scheme of 1952. However, certain individuals are not eligible to receive benefits, including major sons, major sons of a deceased son, married daughters whose husbands are alive, married daughters of a deceased son whose husbands are alive. Let's take a closer look at two specific clauses related to payment entitlement. Para 70(3) outlines that if neither of the preceding clauses, 70(I) and 70(2), apply, payment should be made to the individual who is legally entitled to receive it. Para 72(1) addresses a situation where there is no nominee and no legal person entitled to the payment. If the amount credited to the fund is less than or equal to 10,000 rupees, the Commissioner may release the payment after conducting an inquiry and confirming the claimant's entitlement. These clauses ensure that proper procedures are followed in cases of legal ambiguity and help maintain transparency in payment distribution. Next, we will go over the hierarchy for payment in cases involving a minor. First, the guardian appointed under the Guardian and Wards Act of 1890 has the right to receive the payment. B. If this is not applicable, the guardian appointed by the member, as per paragraph 61(4)(a), will be next in line. C. If neither of these applies, the natural guardian of the minor will be entitled to the payment. D. Finally, if none of the above guardians are applicable, the Commissioner may deem a suitable person to receive the amount, provided it does not exceed 20,000 rupees. For amounts exceeding 20,000 rupees, the Chairman of the Central Board of Trustees will decide who the proper recipient is. This sequence ensures that payments for minors are handled responsibly and in accordance with legal provisions. In situations where payment is to be made to a person deemed legally insane, Para 72(3)(a) outlines the following order of recipients. First, the payment goes to the manager appointed for the lunatic's estate under the Indian Lunacy Act of 1912. Second, if no such manager exists, the natural guardian of the lunatic is entitled to receive the payment. Finally, if neither a manager nor a natural guardian is available, the Commissioner can decide who the appropriate person is for amounts not exceeding 20,000 rupees. If the amount exceeds 20,000 rupees, the Chairman of the Central Board of Trustees will determine the suitable recipient. Para 70(a) addresses a specific scenario involving the provident fund of a deceased member. If an individual who is entitled to a share of the deceased member's provident fund is accused of committing or aiding in the murder of that member, their share will be withheld until the case is resolved. If the individual is acquitted of the charges, the withheld share will be paid to them. However, if they are convicted, their share will be equally distributed among the other beneficiaries entitled to the Provident Fund accumulations. This provision ensures that no wrongful payments are made while a criminal investigation is ongoing. Let's now go over a few important provisions. Para 74 states that the annual report and audited accounts, as certified by the Controller and Auditor General, must be approved by the Board and then presented before Parliament. Para 76 provides that if any individual is found guilty of violating a statutory provision, they may face up to 1 year in jail and/or a fine of up to 4,000 rupees. Para 78 grants the central government the authority to issue directives for implementing the Employees Provident Fund (EPF) scheme. Finally, Para 79C outlines the composition of the Board of Trustees for exempted establishments and specifies the terms and conditions of service for these trustees. These clauses ensure transparency, accountability, and the proper administration of the EPF scheme. There is no pay ceiling for eligibility in respect of newspaper establishments. An employee is eligible if they have completed 3 months of continuous service or have worked for at least 60 days within a 3-month period, whether in the same newspaper establishment, in another establishment under the same employer, or partially in both. Additionally, if the employee has been declared permanent, they are eligible from the earliest date among these conditions. This coverage extends to all employees, including working journalists, employed in or connected to any work within a newspaper establishment. A cine worker refers to anyone employed, either directly or through a contractor, in connection with the production of a feature film. This includes artists such as actors, musicians, dancers, or those performing skilled, unskilled, manual, supervisory, technical, or artistic work. A cine worker is eligible for Provident Fund membership if they have worked in at least 3 feature films with 1 or more producers. Their monthly wages must not exceed 1,600 rupees or, in the case of lump sum payments, the total annual remuneration should not exceed 15,000 rupees. Certain provisions apply to employees with disabilities as defined under the Persons with Disabilities Act, 1995, and the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities Act, 1999, with certain modifications. In Para 2F, it states that if the employee's pay at the time of becoming a fund member exceeds 25,000 rupees per month, they are subject to this provision. In Para 30, the central government will contribute the employer's share of Provident Fund contributions for a maximum of 3 years from the date the employee with a disability joins the fund. This applies whether the employee is hired directly by the employer or through a contractor. These modifications, however, do not apply to international workers. Para 2A, under Para 83 of the EPF scheme, 1952 addresses contributions for Indian and non-Indian employees working internationally. For an Indian employee, this applies if they have worked or are going to work in a foreign country with which India has a social security agreement. These employees can avail benefits under the social security program of that country, based on eligibility gained under the agreement. For a non-Indian employee, this provision applies if they are working for an establishment in India covered under the EPF Act, and they hold a passport other than an Indian one. Additionally, there is no pay ceiling for international workers, IWs. Contributions are made on the full salary by both the employer and employee. These contributions are calculated on the total pay, regardless of whether it is paid in India, abroad, or on a split payroll. Pension payments are provided for life upon retirement or superannuation. Similarly, in the event of disablement during employment, the pension is payable for life. For members covered under a Social Security Agreement, SSA, a withdrawal benefit is available if their service is less than 10 years after totalization. Additionally, pension benefits are exportable, and totalization is applied as per the terms of the SSA. The chairman is responsible for calling a meeting to elect members representing employers and employees. During the meeting, nominations are proposed and seconded. If the number of nominations exceeds the available vacancies, an election is conducted through a secret ballot. The results are declared based on the highest votes, and in the event of a tie, the outcome is determined by drawing lots. The chairman of the Central Board has the authority to establish a regional committee by issuing a notification in the Official Gazette. This committee operates under the control of the Central Board. The composition of the committee includes a chairman, appointed by the chairman of the Central Board. 2 persons appointed by the chairman based on the recommendation of the state government. 2 employers' representatives, appointed in consultation with recognized employers' organizations in the state. 2 employees' representatives, appointed in consultation with recognized employees' organizations in the state. Non-official Central Board members who reside in the state. Additionally, the chairman may appoint up to 5 more representatives from employers or employees if necessary. The regional committee plays an advisory role, offering guidance to the Central Board on matters referred to it. Additionally, it provides general advice on administering the scheme within the state, with a focus on the progress of Provident Fund contribution recovery, expeditious disposal of prosecutions, speedy settlement of claims, timely rendering of annual accounts to fund members, and quick sanctioning of advances. The regional committee is automatically dissolved once a state board is constituted for the state. The chairman, vice chairman, and trustees of the Central Board serve a term of 5 years. For the executive committee, the chairman and members serve for 2 years and 6 months, while the chairman and members of regional committees serve for 3 years. All appointees continue in their roles until their successors are officially appointed. Trustees or members filling casual vacancies serve the remainder of the original term. Outgoing trustees or members are eligible for reappointment for a maximum of 2 terms, except for official trustees or members. Non-official members who have already completed 2 terms may continue under specific conditions. Trustees of the Central Board or members of the Executive Committee can resign by submitting a resignation letter to the central government. For regional committee members, the resignation must be submitted to the chairman of the Central Board. The resignation takes effect once it is accepted by the relevant authority. A trustee or member who fails to attend 3 consecutive meetings without permission automatically ceases to hold office. However, they may be reinstated if reasonable grounds for their absence are provided. Individuals are disqualified from serving as trustees or members if they are declared of unsound mind, undischarged insolvents, convicted of offences involving moral turpitude, or default on payments due to the Central Board or Fund. Any disputes regarding disqualification are resolved by the central government, whose decision is final. The central government or the chairman of the Central Board may remove a trustee or member if they no longer represent their constituency's interests or default on payments. Removal can only occur after giving the trustee or member, and their representing body, an opportunity to respond. Non-official trustees or members must inform the chairman if they plan to be away from India for more than 6 months or resign. Failure to notify or absence for 6 months or more results in automatic resignation. Let's take a look at how the wage ceiling for Provident Fund contributions has evolved over the years. From 1 November 1952 to 31 May 1957, the wage ceiling was 300 rupees. From 1 June 1957 to 30 December 1962, it increased to 500 rupees. Between 31 December 1962 and 10 December 1976, it rose to 1000 rupees. From 11th December 1976 to 31st August 1985, it reached 1,600 rupees. From 1st September 1985 to 31st October 1990, the ceiling was 2,500 rupees. Between 1st November 1990 and 30th September 1994, it increased further to 3,500 rupees. From 1st October 1994 to 31st May 2001, it was 5,000 rupees. From 1st June 2001 to 31st August 2014, the wage ceiling was 6,500 rupees. Finally, from 1st September 2014 onwards, the current wage ceiling is set at 15,000 rupees. This progressive increase reflects the growing economic conditions and adjustments to keep up with inflation over the decades. Thank you for watching. For more informative videos, please access our bouquet of programs.